Plausible isn't proof, and discretion doesn't fix that problem. One of the biggest problems in family law is that courts, lawyers, and litigants constantly confuse what sounds plausible with what is actually proven. Those are not the same thing. A plausible story is simply something that sounds believable. It fits a narrative. It feels emotionally coherent. It may even be correct, but evidence is different. Evidence is something you can point to in documents, testimony, data, or the actual record. And in family law, especially in child custody disputes, courts sometimes drift from evidence into mere plausibility without fully realizing it. You hear two phrases constantly in these cases. The court has broad discretion and the court determines credibility. Both statements are true. Both are also sometimes used to shield decisions grounded more in intuition than proof. Here is the core problem. A plausible account satisfies logic. An evidentiary account satisfies proof. In too many cases, courts accept narratives that merely sound right without demanding reliable evidence that they are actually true. Once a judge or commissioner decides a story feels plausible, confirmation bias often begins creeping in. Every subsequent fact starts getting filtered through that narrative. Eventually, the narrative becomes a formal finding, and at that point, it becomes very difficult to challenge on appeal. This is what I call the plausibility trap. If a story sounds like something a controlling or unstable person would do, sometimes the system stops asking whether the person actually did it. Now, when people hear broad discretion, they often misunderstand what that means. Broad discretion is not a license to guess. It does not mean a judge can simply choose whichever story feels emotionally satisfying. Discretion is supposed to mean choosing among legally permissible outcomes based upon established facts. The same thing applies to credibility findings. Courts are allowed to believe one witness over another, but credibility determinations are supposed to have a rational basis grounded in evidence. Inconsistencies, corroboration, or documentation. Simply saying, I find this person more credible, without explaining why, risks turning credibility into a placeholder for intuition. This problem appears constantly in custody disputes. One parent accuses the other of being emotionally abusive, controlling, or unstable. The accusation is often built from a handful of selected text messages or isolated incidents. The story hangs together emotionally. It sounds plausible. But where is the corroboration? Where is the context? Where is the evidence of actual harm? Too often, plausible concern quietly becomes treated as proven fact, and once that happens, the accused parent is often forced into the impossible position of trying to prove a negative. The discipline that fixes this problem is simple. Stop asking, does this story make sense? And start asking instead, where is the evidence? If you cannot point to actual evidence, you do not have proof. You have a theory. And theories, no matter how emotionally satisfying, are supposed to be insufficient in a court of law.